Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And can you believe it's only been 4 days since I came to you urging support of Constitutional Amendment number 2, and in that feature we emphasize the fact that the Attorney General for the state of Louisiana, Ms. Liz Murrill, she stated that a lawsuit filed to try to block this measure from even being on the ballot was, and I quote, frivolous. And I did say in that feature that I concurred with Attorney General Murrill, and we're going to break away for just a moment and let you see, or I'm going to repeat, why I concurred with Attorney General Liz Murrill's sentiments about that lawsuit. We'll be right back. Let me just say this. Whenever something like this comes up, it's inevitable that there's going to be litigation, I guess. We are the most sue-happy state I know of. So there's been litigation. You may have seen it that has been filed. It's filed by a gentleman named William Most, who is an attorney in New Orleans. And Attorney General Liz Murrill has referred to this litigation, and I quote her on this, as being frivolous. To be perfectly honest with you, I agree with her that this is frivolous litigation. She is asking the Supreme Court to intervene and go ahead and toss this suit out. I hope that that happens, but I believe that it should, and I believe she is correct that this lawsuit should be tossed out, and I'm going to tell you why. We can all stipulate to the fact that the turnout for this election is going to be very low, okay? You don't have some dynamic personality on the ballot. It'll probably be a little bit higher in St. George because they have a mayoral election on the ballot. But by and large, this is going to be an extremely low turnout election. That being the case, people that go out to vote on nothing more than constitutional amendments, typically they've done their homework, okay? And I'm going to do something that I don't do often. I'm going to compliment the advocate, and we're going to provide a link for a highly detailed feature that they did on all 4 of these amendments. That's enabling you to do your homework. What Mr. Most is basically saying, and he says it falsely portrays the positives without relaying any of the negatives. My counter argument to that is exactly what I just said. He's wanting to treat us like we're school children and we're going in to take an exam and we haven't studied at all, okay? We just go in there and, okay, the teacher puts it on there. Oh, well, I don't know the answer. I'll guess and hope I do the best. That is not indicative of the type of diligence that will have been done by voters who vote in this election, okay? They will have studied it just like you would study for an exam, okay? So I think it is disingenuous and quite frankly insulting to voters to say that we don't have the ability to do our homework and make up our minds. And I don't need to read the language. I know how I'm going to vote. I don't need to read their little synopsis, okay? And I think that's going to be true of 99.5% of the voters who enter that voting box. All right, I'm not going to repeat what I said because I think I said it eloquently 4 days ago when we brought the feature urging the support for Constitutional Amendment 2, but I will tell you that late last night the Supreme Court weighed in on the matter, and I do take great pride in this because I think you're going to find their wording to be pretty doggone similar to mine. We'll give you the link for an advocate article about the Supreme Court's ruling late last night, but I want to read it at this time from that article. Again, we'll give a link for it. They said, quote, "We find the ballot language for the proposition at issue is framed in, quote, simple, unbiased, concise, and easily understood language," close quote. It says the ruling further says, quote, "There is no requirement that every detail of the proposition be stated on the ballot," close quote. The advocate goes on to say the ruling also says the ballot language need only include, quote, "sufficient information to identify which proposed amendment the voters are voting for or against," close quote. and that the full amendment has been publicly available online for 3 months. It also says the plaintiff's arguments that Amendment 2 doesn't meet technical requirements for ballot measures laid out in the Constitution have, quote, no merit, close quote. So, what we've had here is a colossal waste of taxpayer resources to go in and litigate this matter. And I want to give a special shout to Attorney General Liz Murrill for her tenacity in fighting this, for her willingness to say in stronger language than I would have used, but I commend her for doing it. She said the lawsuit was frivolous. She said the judge got it wrong, and I think that the wording of the Supreme Court validates her contentions. They also validate my statements that the plaintiffs in this lawsuit and the attorney who filed it, William Most, have insulted us in thinking that we don't have the capability to go in and study for an exam, the exam being when we vote. And I readily said, I'm not going to read any one of the 4 on that ballot. I'm not going to read them. I already know. I've done my homework. Turnout's going to be low. Folk will have done their homework. I want to again urge everyone to support Constitutional Amendment 2 as well as the other ones. But I tell you what, in ensuring everybody can do as much homework as possible, we're going to do a separate video that was from the Baton Rouge Press Club for the date of February the 24th. I believe that's correct. Don't hold me to it, but I believe that's the date. Dr. Stephen Procopio, who is the head of the Public Affairs Research Council, he talked about the amendments. And we're going to do one video of him not only explaining, now let me just say one thing. Unlike me, he cannot take a position pro or against. It's his job to just objectively state the facts of what's in the proposition. The amendment. So he doesn't have the kind of latitude I do to stand up in front of you and say, I wholeheartedly support this, which I do. But we're gonna put that segment of his presentation that dealt exclusively with Amendment 2 together with any questions, and you'll have to forgive me, it's been a month, my memory's not what it used to be, any questions he may have fielded with regard to Amendment 2. We're also then going to provide a separate link that you can click on to watch his presentation in its entirety to have him explaining all 4 of the constitutional amendments. That's what I meant by this is modern day technology that Mr. Most, the attorney, apparently doesn't feel like we're capable of utilizing. I did find the lawsuit insulting. I'm not going to mince my words on that. I took it as a slap in the face that me and others don't have the ability to go in and do our homework on this. So with that, I want to conclude by encouraging everyone, because I believe this is badly needed, an amendment that badly needs to pass so that we can begin on the road to becoming more competitive economically with Texas, because it's going to be extremely difficult to start putting in more exemptions if this constitutional amendment passes. And that, in my opinion, is what has got us in the mess we're in now. And make no mistake, from a tax standpoint, we're in a mess. So I commend Governor Landry and obviously Treasury Secretary, Revenue Secretary Richard Nelson for his efforts to start moving us significantly in the right direction. And I cannot urge any more strongly than I know how. If you like to early vote, you have until Friday. But if you don't early vote, remember, March the 29th. These things are very easy to forget when that's all that's on the ballot. I want to strongly encourage you to go out, support all 4 amendments, but this in particular, Amendment number 2. Thank you so much.